Daniella TREPP versus Mark TREPP, and the appellee will not be permitted oral argument because no brief was filed. Is this easier or harder when you don't have any opposition?
Can I reserve 5 minutes? I'm Horace Smith with Smith, Hood, Perkins in Daytona Beach, representing the former wife, the appellate. This is basically a classic case, assuming that you know the facts. It's a classic case of alimony, but the court, for no reason set forth in the final judgment or the denial of the motion for new trial, failed to mention either denial or granting of alimony, and did not award so.
Let me ask you something. Is there any way to justify, that the trial court could have justified giving the marital home to the wife other than lump sum alimony?
The court could have, possibly. However, the marital home was in foreclosure, which took place. But the court made an equitable distribution of that matter. It gave the marital home while in foreclosure to the wife. It gave the second home and all of the basically tangible property of the marriage that the husband had accumulated.
I mean, but if you look at the finances, the debt that the husband was saddled with and that kind of thing, that's certainly not an equitable distribution if that home, if she was able to get the equity out of the home, which we don't know. I mean, that's the problem.
That's probably true. And yes, you're absolutely correct. The court could have made that justification, saying I'm making a lump sum alimony award, but it didn't do that either.
Let me ask you this. If the house was sold the day before the trial, and there was $80,000 sitting in an escrow account, and the trial judge said, I give this $80,000 to the wife as lump sum alimony, would that have been within the trial court's judge's discretion as far as an equitable, fair resolution of the case?
I don't believe so. I think that the court certainly had that discretion to award lump sum alimony. But
so you're saying that even if she had gotten $80,000, that as a matter of law, the judge would have abused his discretion by not giving permanent periodic alimony on top of that?
I still think that permanent periodic alimony would need to be awarded. Of course, the $80,000 she's gotten has to be reduced by the equitable distribution which the husband received. He had his mobile home, his vehicle.
But what he got was less than the debts he got, so he was in the negative.
Well, he got $18,000 of credit card bills.
Right. He got what? Mobile home worth $5,000, truck worth $3,000 or $4,000, so he got negative.
Correct.
Okay, so she gets $80,000. So obviously, it's not a matter of equitable distribution; it'd be support. Now, $80,000, I mean, you can look at it as, it's $10,000 a year for 8 years until she could get Social Security, and he could get, and then she would get 50% of his pension from, when he retired. So, I mean, to me, the $80,000 may not be unreasonable, except we don't know if she's getting the $80,000.
Well, but we're putting in some facts and not in evidence. Number one, and the judge recognized that the house was in foreclosure, and recognized.
But I'm saying leaving out the foreclosure factor. Like I said, if she got $80,000, the house was sold the day before, and we knew there was $80,000, and the trial judge knew there was $80,000. Would that be within the trial court's discretion, instead of giving permanent periodic alimony, to give lump sum alimony of $80,000, taking into account the parties' ages, taking into account that he had awarded her 50% of his retirement pay when he retired, taking into account that Social Security was only so many years away, et cetera? Would that have been within his discretion?
It's within his discretion to award it. Would that take away the fact that she should get permanent periodic alimony? The answer is no, and the reason for that is that, number one, she didn't have Social Security coming, which is assumed in your factual situation. And there was no finding that she would even be eligible for Social Security because, as the court found, she'd been primarily a housewife during her married years, and she really had no marketable skills. Had worked part-time as a home health care under the table, as the testimony had indicated, and really didn't have that Social Security. So your factual situation, I mean, we're assuming a lot of facts. If she didn't get the $80,000, then there was going to be Social Security. That's not in the equation. So there'll still be this particular problem. We have a 30-year marriage, and then the 61.08, every factor which is listed.
Do we have a 30-year marriage? And our court has a case where we kind of avoided the issue. They were married 20 years, and then they were separated a few years, and then they were married 9 years, and our court actually, I think, calls it gray area. So is there any case law that says that,
Plenty of case law.
is there any case law that says that you add the two together in determining whether it's long-term marriage?
Yes, sir. Yes, sir. And
What case is
that's
that?
cited in the particular brief, and of course was not contested because there was nothing on the other side.
What case says that if you add the two to determine whether it's long-term or short-term or gray area?
I take it back. I don't believe I cited it because it wasn't an issue. But the court found that there was basically no separation of the parties at all. So it wasn't a 2-year hiatus, as you indicated. There was no separation, and also found that the agreement that they had made was non-executory. In other words, the wife in the first divorce.
I'm just asking very simple. Are there any Florida cases which say when parties remarry that you either just go with the length of the second marriage or that you add the two together? Are there any cases that have a clear hold?
Yes, sir.
All right, and what's that case?
Well, I can't give you the name of the case.
It's not in your brief either, right? I mean,
it was not an issue. I did not cite my brief, but there are several cases which indicate under the factual situation. Let me make sure that the factual situation, when there had been no basic non-executory agreement in the first case, if there was an agreement, and a very short period of time in separation and the parties continued, there are several cases which indicate that the court can treat that as a long-term marriage. Notwithstanding that, even if that were the case, this would be a gray area marriage, 11 years. And under 61.08, the factors still have to be considered. And the court actually considered them. The court made findings of fact that even if this was a gray area marriage, basically, that she'd still be entitled to alimony. I mean, every factor is there. Age, the disparity in the earning ability of each of the parties, the health of the parties, the length of the marriage being the only factor to put in the gray area, the standard of living, the fact that the wife was awarded alimony, that the husband never paid, and this was the reason that the house was in foreclosure. Every factor in the 61.08 subsection 2 is listed.
Counsel, if we do remand this case, I don't know whether we will or not, shouldn't we tell the trial judge that it ought to look into whether your client impeded a reasonable sale of the house and thus dissipated its value, and take that into account?
Yes, sir. I think that should be. Well, I don't think you need to tell them that. I think you need to remand the case, and the judge should take that into account, as whether or not, as Judge Vander said, whether or not the house sold and it was $80,000. That's certainly a factor. If she dissipated the house, then that should be a factor, but that's not the evidence. The evidence is that he didn't pay the alimony, and therefore the mortgage payment was not paid. In fact, his testimony was that he was originally sending some $5,000 a month. When we filed for divorce, he quit sending any money, and even though the court awarded $2,000 a month alimony, he refused to send any because he had his own bills to pay.
It's not relevant to our decision, but I'm consumed with curiosity as to whether that house has been foreclosed.
My understanding...
It's out of the record, so you don't have to answer it.
But my understanding it was, but once again...
Well, that's something that the trial judge will have to wrestle with, isn't it?
Absolutely. He should. Use my reserve minutes too.
Thank you very much.